Gauteng High Court has reserved judgment in the case between Public Enterprises Minister Pravin Gordhan and the Public Protector. Now, this is in relation to Busisiwe Mkhwebane's report on Sars' so-called rogue unit. Now, Mkhwebane wants President Cyril Ramaphosa to act against Gordhan within 30 days of the release of her report. Let's talk about the arguments from both sides. Let's see what he feels about what he heard. That's legal expert Ulrich Roux. Ulrich, good morning.
Hi, good morning, everyone.
So, from what you heard, and I'm not sure if you were watching the entire going on in court yesterday, but who do you think made the better argument with all this tit-for-tat and drama that we saw around the story?
I think if one has to weigh up the two parties' interests, Minister Gordhan stands to lose more than the Public Protector. And the reason why I say that is because the remedial action which the Public Protector enforced or is trying to enforce in a report is effective basically tomorrow. So tomorrow she has instructed the SAPS Commissioner to investigate possible criminal action by Minister Gordhan, as well as the Speaker of Parliament, to inform members of Parliament about this report. Now, that could be damning for him, obviously, whereas if you had to weigh up the interests of the Public Protector, pausing her remedial action, which is contained in a report, would not lead to any prejudice being suffered by her. So I think if one had to look at it from that angle, the Minister stands to lose more, and I think that his argument accordingly was stronger yesterday.
Well, also, I mean, her counsel's sort of their scathing arguments against Pravin Gordhan's application was that he was insulting and undermined the office of the Public Protector. Is that what you got from that argument?
No, not really. I think that he tried to carry his point across strongly, and you know, as we say, or as the cliche rings, the best form of defense is to go on the offense, and that's obviously what he did. But I think important for everyone to remember is that, remember in 2016, the High Court, with the whole Kandla saga and the Public Protector, the High Court ruled that the Public Protector's remedial action is enforceable until set aside by a High Court or by a competent court. So, you know, taking that into regard, the Minister has now exercised his right to take the report on review. And if this interdict is not granted, that is why it is so important, then that remedial action needs to be implemented immediately until set aside. So that is why there is so much attention and why it is of such importance that he did bring this interdict application.
Well, throw the EFF into the mix now also, and taking their part and saying that they're not defending Mkhwebane, but rather the office that she holds, to that point that you just made about the Public Protector in general and on Busisiwe Mkhwebane. Did they have a point as well?
Yes, so they joined the proceedings as a friend of the court or as an interested party, and I think there was quite a valid argument made in that, you know, if we keep on curbing the rights of the Public Protector and setting aside her remedial action all the time, then we're basically taking all her powers away, or the Public Protector's powers away, and leaving it toothless, so to speak. So, good argument as well, but remember that there's always two sides to a story, and there's always two arguments to a story as well. So that's why I'm saying, if one had to weigh up at the end of the day the prejudice that could be suffered by the Minister, I think that it is more serious than that could be suffered by the Public Protector.
Some might say three sides to a story, Ulrich, always. There's that truth in between that we often don't hear about. So how do you see this panning out? I mean, just from what you heard, how do you see this panning out? It's an urgent matter, as we know.
Yes,
and as the judge herself said.
So the judge has reserved judgment until early next week. She said either Monday or Tuesday. It is an urgent application because of the relief sought, the interdictory relief sought. But having regard to the arguments led yesterday, you know, when a lawyer can never predict accurately as to what a judge is going to find at the end of the day, but I do think that...
Especially under such pressure.
Definitely.
So do you think that might affect things, at the short time she has to make this decision?
Well, that is the nature of an urgent application. You know, the judge needs to think on her feet. All the normal rules pertaining to time frames and that falls away. But having said that, you know, the papers are all in front of her. She's got a few days to make the decision now. And I do think that Minister Gordhan will be successful in her his intellect
If he
application.
isn't, what are his options after this?
Well, he could then possibly take a decision on appeal, but as I said, you know, the Public Protector's findings are enforceable until set aside by a competent court, and that is the danger for him.
Okay, so wait and see. Let's see what happens. Thank you very much. Just breaking it down simply for us, and that's our legal expert, Ulrich Roux. And we'll know, I suppose, in about, well, not too long from now as well, that deadline looming tomorrow.